Hello, and welcome to another Participatory Defense First Hub webinar. My name is Hakeem Crampton. I am the Government Relations Liaison for Citizens for Prison Reform, and I'm excited that you've decided to join us today for this conversation in and around the work we do with supporting families that are impacted by the criminal legal system. So if you are joining this webinar today to learn more about one of the facets of supporting your loved one, if your loved one, or even if yourself is experiencing court involvement in the Ingham County or Lansing, Michigan area, this webinar will be suited just for you. Previous webinar, we discussed, myself and Ms. Barb Pash, discussed the background behind the court processes itself. The district court, the circuit court, what happens from arrest through arraignment, through pre-trial, et cetera, all those various areas were covered in that webinar. So if you're joining this webinar will be discussing some of the courtroom language, some of the most fundamental words and terminology that's often used in the courtroom between judges, lawyers, prosecutors, et cetera. So this will be fundamental and important to you if you will be sitting in the courtroom because you will be experiencing it yourself, or you will be there to support your loved one, and to understand sometimes maybe the communication with an attorney or the prosecutor's office information, these words. So it'd be great at this time to get you a pen, jot some of these words down, take some great notes, rewind this back and watch it again. But this will cover the courtroom language, so to speak, a glossary or dictionary of courtroom language. We're going to kind of cover it alphabetically. We're not going to cover chronologically because a lot of these words can pop up at any given time in the criminal legal system process, right? So we're going to kind of cover them alphabetically, starting with the word acquittal, which refers specifically to if a person goes through the court process after being accused and charged of a crime and is found not guilty. That is called an acquittal. That's what the word acquittal means. There's another fundamental word that starts with an A, admissible. Admissible is a word that specifically refers to evidence in specific, and that means that the evidence or the collection of information or documentation or material, etc., that's being used in regards to the case, because evidence don't always mean that it's evidence that points to guilt per se, or even innocence. That's not the only definition of evidence. Evidence is anything that's collected that's pertinent to the case, so it could be an associated portion of information that connects another dot, and people, connect the dots, so to speak, of the evidence to build a full picture of either, the defendant, which show the dots that the person is innocent, or the prosecution will show the dots that the person is guilty. So it's all those evidentiary pieces. And some evidence is direct evidence that indicates that a person is innocent or guilty, etc. So that's what it means to be admissible. Means to be that it's permitted to be used in the courtroom. That it's something that can come in, that can be heard by a judge or heard by a jury, right? Another word that is often used in the criminal legal system process is affidavit. An affidavit is a document, a sworn statement that someone takes outside of the courtroom, but in the presence of someone who's capable of taking their sworn testimony or their sworn statement after they've said that what they're stipulating is true and factual according to perjury. So that's what an affidavit is, and this can be used in a lot of different spaces and places throughout the court legal process. Affidavits are used in many different places. Can be used to collect a statement from someone who may not be able to show up in court. So you get an affidavit for them. Maybe it's exonerating your loved one. Maybe it proves that you were innocent and you didn't do it, or some other form of pertinent information. You can collect an affidavit for them and present that in court. The courts do it as well, etc. So there's a lot of different usage of affidavits. There's a form of what's called an Alford plea. And an Alford plea is when an individual says that, for example, you guys built up a case against me. I don't admit that I'm guilty of it, but the courts or the state has built up a case, and they might be able to find me guilty, but I'm not admitting that I'm guilty. That's called an Alford plea. So your loved one could perhaps be in a predicament to take an Alford plea. there has to be some discussion as well as with the judge to allow an Alford plea. It has to be presented and asked, is Alford plea acceptable in this particular case? Sometimes the judges say no. Sometimes the prosecution doesn't want an Alford plea. So there can be some good dialogue, and oftentimes it's fundamentally available. Another word is alternative, for example, and that could appear in a lot of different places. Alternative sentence, and particularly alternative sentence, but alternative to incarceration, such as diversion. So that word could come up, and alternative simply means something other than. There's another option, different option other than something else, right? Another word is arbitration. At different levels of the courtroom process, there could be what's called an arbitration. And arbitration is an opportunity to kind of step away from the court process and kind of negotiate a settlement without there having to be a full-blown courtroom process involved with trial and things of that nature. There could be different forms of arbitration. Even plea agreements are a form of arbitration to a great extent because they do avoid the full brunt of the legal courtroom process itself. The right, that's afforded to a defendant, the full right, can be arbitrated and broke down through a plea agreement, so to speak, like an Alford plea, for example, or a plea bargain, as they call it. Arbitration can also be dispute resolution services, for example. That takes place in different courtroom processes. There's dispute resolution service who can resolve a matter and then make a recommendation to the judge to sign that they've agreed upon this, etc. There's another word in the courtroom process, we're still going alphabetically, and it's arraignment. An arraignment is the opportunity for both parties, essentially a person who's been arrested, to appear before a court, before a judge, and there's what's called the arraignment, in which the charges are placed out there, and not much of an opportunity to have mitigating circumstances, but there's a space for which now there's a counsel at first appearance can appear and seek to get you a bail, seek to mitigate the charges, etc. So the arraignment is the initial stage of being charged with a crime in a courtroom. The next word would be a word like bail or bond, right? And bail and bond are kind of, the same thing, but they operate just a little bit different depending on what the judge orders when it comes to a type of bail or bond. And a bail or a bond essentially is an opportunity for someone who's accused of a crime who's been arrested to actually get released pending the outcome of the case, right? There's different levels of it, different levels of bail and bond, but that's essentially what it means. There's also a word called the bench trial. A bench trial, which is the opposite of a jury trial. A bench trial is before a judge, where the person that says, well, I want to go and have the judge hear all the evidence and hear the whole case and decide whether I'm innocent or guilty, whether my loved one is innocent or guilty. A jury trial is when a group of people is selected, pooled from society, so-called amongst our peers, amongst our neighbors, so to speak, right? But nevertheless, that's what a bench trial and jury trial. The next is what's called a brief. Now, a brief is a document that is filed. Generally, it's a motion. We call it a motion because you motion the court to hear a plea is what it is. When, whether it be the prosecution filed a motion before the courts or the defendant filed a motion before the court, you motion the court to hear your pleadings in this motion, right? And it could be a motion relative to why you're requesting sequestration of the jury, or why there's a co-defendant and you want separate juries, as opposed to oral arguments. You could orally argue it before a judge as well. And the brief is the opposite. Instead of an oral argument before a judge, it's a written argument, so the judge can get a chance to really read and comprehend. If it's a really deeply profound issue that needs to be, heavily considered, then it's not something you just orally argue, you want to, or it could be a combination of both. You will orally argue it and then present briefs to support, your oral argument. And it can be used at different stages, many different stages in courtroom processes, but that's what a brief is. It's a written argument to a judge. Another word is burden of proof. The burden of proof generally rests with the prosecutor to prove that an individual is guilty of what they're accusing of them, and that's the burden of proof rests with them. That essentially means that a person don't have to say or do anything but show up, and the prosecution has to prove that this individual is guilty. All right, that's what the burden of proof really means. You don't have to say or do it. You don't have to exercise anything but your right to remain silent throughout the entire process if you choose to. But of course, we recommend that you defend yourself and present evidence and fight the charges. Another word is capital offense. Capital offense usually refers to an offense that took a life, right? That in certain states, capital punishment would be the outcome of someone being found guilty of a capital offense. Nowadays, a capital offense in many other states just refers to an offense that took a life and could get a person, or necessarily took a life, but it could get a person life in prison. That's generally the understanding of a capital offense, generally speaking. There's a case file. A case file could consist of a lot of different things in the courtroom. There's a lot of different forms of case files. Case file could be the entire docket, right, of the case, all the records, all the forms that's been filed, all the briefs, the motions, the forms that's been filled out, everything that's relative, court records, etc., court reports, all that could be, a case file. The docket, the motion to discovery material to an arrest, etc. That's generally a case file, right? So another word is case law that you could hear often. The prosecution and the defense, and oftentimes the judge, will talk about case law that's sets a precedent for conversation or discussion that's being had inside the courtroom, right? The clerk of the court. The clerk of the court is the person that's generally in charge of all the documentation and filings with the court. They're in charge of the schedule of the judge and the courtrooms, the various branches, etc. that they may handle, and then some judges have their own clerks as well, right? But there's a clerk of the court, and then there's clerks of the judges, right? Another word is concurrent sentence versus consecutive sentence. This is when a concurrent sentence is when there's going to be more than one sentence imposed, and the judge imposes the two sentences to run concurrently, meaning together as one sentence. So the person is sentenced to 10 years and on one charge and 10 years on another. That's generally 20 years. Concurrent means together. So those 10 years operate together. Consecutive means those 10 years will operate opposite of each other. So there's a 10 years plus 10 years, total 20. Complaint. A complaint is a filed document in many different ways with the courts, or to file a complaint with the prosecution, file charges, generally speaking. A complaint says that, this is the accusation, the charges, and here's the narration of what has occurred that led up to these charges, right? That's generally what's speaking about what a complaint is. A conviction is when someone's been either found guilty of a crime, or has pled guilty and accepted a plea to an offense, and then there's a judgment entered by the judge that accepts that plea or accepts the verdict from a jury, and then at that moment when it's accepted, it's entered into the record as a conviction, right? That's what a conviction is. There's also what's called counts, and a count refers to a charge. A person generally could be charged with more than one count, could be charged with more than one count, right? So a count is a charge. Charging is just a pleading before the court that says, I bring, the state is to state what they do. I bring before the court a pleading, of a charge of multiple counts, such counts of so-and-so. That's what it refers to, a count. In the courtroom process, cross-examination happens. Cross-examination is when there's a direct examination. Someone calls a witness. The prosecution calls a witness, for example. We'll give an example. And that prosecutor will direct examine that person. And then the defense will have a chance to cross-examine. And then there can be some follow-up, some redirect and et cetera. There can be some follow-up, but that's what cross-examination means. Court reporter. Court reporter is a person who keeps the record of everything that's being said. And they type in shorthand version, and they're, able to summarize through short typing and then reproduce a report word for word what was said in the courtroom. Defendant is someone that's been charged in the courtroom. Deposition. A deposition is a statement that's taken under oath, generally outside the courtroom, where people can be deposed, is what the word is, where you can be questioned under oath outside of the courtroom, and that information can then be taken back into the courtroom and used during the courtroom process proceedings. The discovery. The discovery is generally the collection of evidence that the police has gathered and presented to the prosecution, and then the prosecution has then, gathered those documents all together, and it's called the discovery material in many states. Some other states it may be called other material, but the case file, etc. Dismissal. A dismissal is when the judge dismisses a case, or when the prosecution asks the court to dismiss charges, or when the defendant files a motion to dismiss charges and the judge grants it. It's called a dismissal, right? There could be dismissals, of course, different types of dismissals, with prejudice and without prejudice, meaning that one or the other, one time they can be recharged and another time you can't be, right? So that's what dismissal pretty much means. The courtroom docket. The courtroom docket is the courtroom case number, and that docket file number, etc., a name, state against so-and-so, whatnot. That's the docket file, right? It's kind of associated with the case file. Due process. The due process is all of the rights afforded to an individual that's being accused according to the Constitution, the United States Constitution, the state's Constitution, etc. That's what the due process allows to happen. And there's a lot of different things that are a part of the totality of due process, and they could be listed. We could list them, but there's tons of pages of what the real full due process is, of what rights a person has that's due them under the law, right? That's what due process means. As we mentioned before about evidence, anything that's collected, that's used in the process to prove either for or against an individual, all that can be considered evidence. There could be, there's exclusionary rule, exculpatory evidence. The exclusionary rule is, things that just simply aren't admissible just by a matter of doctrine. They're just not admissible in law. Certain things aren't. And there's things that are exculpatory. And those are evidence that is for the defendant that says that he didn't do it. He or she is innocent of a crime. These are things that exculp that person, right? It's called exculpatory. Felony and misdemeanors are felonies are offenses that could land you in prison. Misdemeanors are those that can just put you in jail or a fine, or sometimes a combination of both, depending on what the charges and counts are. Grand jury. A grand jury is when a group of citizens, like a jury, is pulled together to review evidence from a prosecution, to indict, to a charge, essentially, to show the judge that there's enough evidence to move forward with charging these individuals, and the judge can then agree indictments are then delivered, right? Individuals in charge of the crime. That's what a grand jury is. Words like hearsay, things that are hearsay, generally not permissible. Impeachment, things that could say that the witness that is testifying is telling a lie, is not being accurate. Their integrity is in question. And we've covered the word indictment, the word judge. A judge is, of course, the one presiding over the proceedings. Jurisdiction relates to where, this courtroom issue could be resolved at. Can it be resolved in this county? Does it arise in this county? If it's a county crime or incident, then the county has purview over it. They have jurisdiction over it. The feds, of course, could have jurisdiction as well. If it's a federal violation, they generally have jurisdiction everywhere. If a crime is committed in another county, that doesn't mean you can be charged in a different county unless there's a connection, and then the prosecutor agrees to let charges be filed in another county, kind of move jurisdiction, etc. That's what jurisdiction refers to. The jury is the group that's been selected out of a pool to hear a case. A magistrate is a judge, oftentimes kind of like pre-trial proceedings before the final judgment proceedings take place as a magistrate. Motions are filed. We covered motions. Motions are when someone files a motion to court. You really motion the court. It's really like raising your hand. It's really where it comes from. The emotion, you raise your hand, essentially. It's what emotion, essentially the origin of it, emotion is. But you motion the court that you have something to say, and asking the judge to decide on your motion, right? Next up is a word that we have called moot that you'll hear in the courtroom. It means that it's invalid. It's not, it's not a real issue. You hear the word objection. Objection, the defense may object to someone being questioned by a certain line of questioning, certain things that they don't want the jury to hear the answer to because it could be prejudicial in a way that's not really permissible. This was we talked about oral arguments, arguing before the judge. Parole and probation are supervision words. It refers to, being supervised after the conviction. It could be after jail or prison, but it means to be supervised, after the conviction. Pleadings, filed responses, we talked about that. Pre-sentence reports, when social bios gathered about an individual that could help inform the judge whether or not, who this individual is, their background, etc., allowing the judge to then weigh that information toward their sentencing. There's pretrial conferences. These are, communications with the judge that takes place before trial, prosecution and defense attorneys rambling, working things out, discussing, things that are going to take place leading up to the actual trial. Preliminary hearing, which is a hearing to discuss, it's after the arraignment, but it's to discuss whether or not there truly is enough evidence to move forward to a trial in this matter. We have the record, which is the file. We talked about that. We have what's called remand, which is generally a word that you could hear if the case is on a post-appeal, post-conviction. It can be remanded back to the court, or you could file an appeal on the judge's decision during the process and put things on hold, and then it can be sent to another appellate court to hear. It can be remanded back to that court to continue proceedings. We have words like sentence, which is an imposed sentence, which generally some of this is known, of course, right? The sentence a judge can impose, probation, jail time, prison, etc. Standard of proof, of course, relates to the degree of proof involved, right? Subpoena, which the court has issued an order in someone to either appear in court or produce some information for the court. Testimony under oath. Testimony refers to someone who has been raised your right hand and sworn that what they say is factual under the oath and under the penalty of perjury. Transcript is the entire transcript of the proceedings. And then, of course, lastly, the verdict. Verdict is when a jury or a judge makes a decision on whether or not someone is innocent or guilty. So this has just been a general discussion of some of the fundamental terms and words you would hear in a courtroom. This webinar was designed to help you along the process. Hope you took great notes. If not, go back, rewind this again, take some better notes. And whenever you go in the courtroom, have your notes ready and prepared to understand some of the language going on, because we don't want you to be in the courtroom supporting your loved one and not able to understand the process that's going on. So this webinar has been sponsored by the Participatory Defense First Hub of the Citizens for Prison Reform. We thank you for joining us. Once again, my name is Hakeem Crampton, and it has been a pleasure talking with you about courtroom language in the glossary and dictionary of words. So be blessed and help wishful ways in supporting your family and loved ones. Peace.